The most interesting conversation coming up on today's edition of The Public Square. I'm Wayne Shepherd with Dave Zanotti. And Dave, there you go. You've been reading articles again, and it's time to take one apart, huh?
Well, Wayne, I hear more and more from listeners saying, I wish we could go to a classroom environment with William B. Allen and have Dr. Allen as our professor to talk with us about things. And so
he's amazing.
When I saw this article that former Justice Stephen Breyer published, and it regards his book and lectures that he's doing right now about his philosophy of what the Supreme Court ought to be all about and what it should be doing, I immediately thought of Dr. Allen. I thought, well, maybe we'll just do an interview and he can talk with us as if we were all students in a class. And I'll try to ask the questions as best I can and let him instruct us on why it is that a traditional judicial philosophy, and there's so many ways of saying it, whether it's an originalist or what sort of term you want to use. But there's two philosophies in the court. One that says this is a living document and you have to kind of make it up as you go along as best you can to help people. And the other says, wait a second, this is a constitutional form of government written in the English language, assigned from we the people to those people who were creating this document and then would become would then put together the Constitution that would become our government. We have a responsibility here, and this document is supposed to reflect where we understand things to be. And what's really important about that is it must reflect our original understandings of what we were doing in the first place. You don't have to reinvent this every 10 years to make it relevant. And if you do want to reinvent it every 10 years, there's a way to do that. Mm-hmm. But it's not by following Justice Breyer's advice. So I turned the task to Dr. Allen, and that's what we're going to hear today, is a classroom experience with William B. Allen on the judicial philosophy that's genuinely constitutional in regards to the Supreme Court.
Well, I'm glad you have that call a friend option, so let's go to it now. Here's Dave and Dr. Allen.
Doc, the reason that we got together on this subject is I ran into an article by former Justice of the Supreme Court, Stephen Breyer. Mm-hmm. And I remember Justice Breyer when we appeared before the Supreme Court in 2002. And I was more than a little bit worried that our case in regards to school choice and a state policy coming up and being challenged so harshly by the teachers' unions and by the ACLU, I didn't know if we had a chance with Breyer. And I didn't know what this was going to be like. And so I was so fascinated at oral arguments by every single question that was asked, and I read every opinion. We didn't have a chance with Breyer, but to my surprise, he asked very, very intelligent questions and very questions that were deeply thoughtful. It showed me that he had clearly taken the data as presented in the case and processed it with great intellectual integrity. And he was asking substantive questions. This was not a narrative encounter. This was someone who really had ideas, who really wanted to hear ideas. And I appreciated that. I had great respect for that. Mm-hmm. Even though I knew we weren't going to persuade him, I thought, at least we're having an honest conversation here.
Right.
So that is a preface of saying that I have respect for Justice Breyer. And he's not here to defend himself today, but I've got to tell you, I think it's time that I need your help on taking on some of the things that he's talking about. Because he recently did an article in Politico, and it kind of hubs into his book, one of his most recent books that he wrote. And he kind of flipped me out in this article. Because one of the things that he basically said, and I'm going to give it just a little bit of a paraphrase, but not much, is he basically said if the court continues to go in the method of interpretation they're currently using, Justice Breyer said, quote, to Politico, we will have a constitution that no one wants. Now, that one fried my circuits because as a student of the Constitution and as a lover of the Constitution, I looked all through Article 3, Article 1, Article 2, 4, 5, 6, 7, all the amendments, and I can't see anywhere where the process of the appellate court, the Article 3 court, that's called the Supreme Court, has any responsibility for creating a constitution that people would like. So can we start from there?
That's probably not a bad place to begin, David. Let me draw your attention to not the article in Politico, but the tagline giving you the keywords at the end of the article, just to place things in context for you. And if you look at that tagline, you will see that what it refers to first is Donald Trump. Secondly, Donald Trump 2024. Then Stephen Breyer. Then Supreme Court justices. That's the order of priority attached to this article. That tells you something about what the article is meant to comment on.
Yeah.
It is meant to comment on the influence and impact of Donald Trump.
You know, this is, I'm so glad everyone's getting to hear and watch. I wish they could all see this process because I've been through this before with you. Just when I think I've got a good place to start the conversation, you point something out to me that I had never considered before. Oh, yes, I always look at now the authors of who wrote the articles because having studied original source documents, and a lot of those being newspaper articles and editorials, you always want to know who's the person that's doing the talking and what are their particular points of view. Well, I never stopped in the modern era to look at the taglines. And here I've got them up. You're exactly right. So there's a tell that we're 4 deep before we get to the subject.
Exactly. The whole purpose of this interview with Justice Breyer was to use Justice Breyer as a fulcrum in what has become known, generally speaking, as saving our democracy. And when Justice Breyer refers to a constitution nobody wants, he's referring to the constitution that a majority choose, but which others don't want and have defined, as it were, prima facie as non-democratic. And so the whole problem with Justice Breyer and his present book, in his earlier book called Active Liberty, in the book in between that he published in 2021, where he defines himself as a pragmatist, the whole problem with all of it is this conception he has that it is the work of the court to protect the people from themselves. And so when he says a constitution nobody wants, he means a constitution that the people might indeed enforce, but which he regards as undemocratic. It can be undemocratic even when preferred by a majority. And that presents us with a real conundrum, a real problem, because that means we have to inquire, what does he mean by democratic? And we put that in context of his general argument in this essay and in the earlier essay, the Active Liberty one, which is really very important. But he calls himself a traditionalist. Now, he uses that word tradition in different ways, and sometimes he accuses the original intent jurist as being traditionalist, and other times he claims himself to be practicing a traditional jurisprudence. And it may be he's honestly confused and doesn't know exactly what he's doing, except this. He knows he's following in the path of the 20th century innovations associated with names like Holmes, Brandeis, Frankfurter, etc. But he's now come to call 20th century innovations traditions. And when he says he's a traditionalist, he means he embraces the last innovation. And he hopes it will be the last innovation because he hopes that the attempt at an innovation in original intent jurisprudence will not stick. Because if it does stick, it will produce a constitution nobody wants, i.e., it will completely reconfigure our constitutional framework in his mind.
Well, and if I'm getting this right, that framework, he basically is sort of backdating about 100 years and saying the framework is what's happened in the modern era, let's say the last 100 years. The ancient era, which would be 1787, 1789, well, that doesn't count anymore.
That's exactly right. And I want to give full credit to Breyer. He has many passages in which he's eloquent about what was intended at the adoption of the Constitution. And he attributes this thing he calls active liberty to those who adopted the Constitution. But in the development of his ideas, he moves backwards and forwards. So he dismisses the founding because of all the things the founders didn't do and the things they did intended to do that were wrong. So he says they intended to exclude women. They intended to exclude Black people. They intended to perpetuate slavery. All those things were wrong. And yet somehow he still wants to argue they created a constitutional framework which was focused on establishing the active liberty of the citizens. Now, by active liberty, he means participatory. That's the very word that he used to describe this thing called active liberty. Whereas the people share, as he puts it, in the sovereignty of the government, of the society. But even that's a misconception. Sovereignty isn't shareable. Sovereignty is exercised by the sovereign authority. If the people are sovereign, that's an integral position. That's not a position of several individuals. That's the whole, all of them, who have committed themselves to a way of life. But he does not see the commitment to a way of life as the Constitution. He sees the Constitution as a continuing return to the question, how do you want to live?
So the Constitution is sort of like a perpetual poll.
Yes, that's Justice Breyer's view. And that's why he could say a constitution nobody wants. It's not the one we want today from his perspective.
Now that, if we're thinking through here, if we've got a minute for just calm and reasonable thought, whether someone's driving their car right now listening to this or listening on their phone, in whatever situation, whatever circumstance, wherever they're listening, that one makes me instantly seasick. I get queasy.
Yes. It ought to make you seasick because it means fundamental instability.
We're going to pause the conversation with Dave and Dr. Allen right there for the moment. You're listening to The Public Square online at thepublicsquare.com. Thanks for listening today. Let's get right back to the conversation now as Dave Zanotti talks with Dr. William B. Allen.
I've got a copy of the United States Constitution in my hands, and it never ceases to amaze me how tiny it is. I mean, this document is tiny. Mm-hmm. I mean, I've got it in small print. I can actually barely read the print without my glasses, but it's if I put it in big print, this might actually be a total of a dozen pages.
Not much more. Yeah.
This is a small document. Let me start by asking you, why is the document so small?
Well, it is clear in the drafting process that the framers intended only to set forth the essentials that are required to establish a government that will protect self-government. Now, I want to underscore the words I just used.
Please.
They wanted to establish a government that would protect self-government, which means they did not see the government itself as the expression of self-government. And this is a mistake Breyer and so many others make. They think our self-government consists in what we achieve through representation. And therefore, we are participating in governing ourselves by electing representatives and having the representatives take on the responsibility for directing our conduct. That's not how the Constitution was written. It was small because it was not written to direct the conduct of all the people in the society. It was, in fact, erected, constructed, framed in order to express confidence in the people's own self-government, each and every one. They were expected to govern themselves, and the institutions of political life were to protect them in governing themselves. What we have experienced in the course of the last century is a complete inversion of that relationship.
We've turned it on its head.
We've turned it on its head. We've taken the government to be wards of the people. And we call self-government the people choosing their keepers. It's as if the animals in the zoo get to choose the zookeepers. That's the theory we're now using. That's Breyer's theory.
It appears that what we're saying is that when the people came together to start this country, their approach was, first, we must govern ourselves individually and as
Yes.
families.
Yes.
That is the first primary place where the protection and the advancement of our human and civil liberties comes from.
Yes.
That we have been given by God certain liberties, and we have a responsibility for those liberties, and it is first and primarily our responsibility. It's not somebody else's responsibility.
Correct.
Once I've got that part of my equation moving, then I go into the broader community. In this case, we'll consider it towns, cities, but ultimately we got to the place of states.
Mm-hmm.
And I must function within the context of my community, my state, and my state government. Then I give power to help me make certain that these basic rights are being protected. And I'm going to create we are together going to create a form of constitutional, covenantal government, agreement government, and we're going to use that tool to further enhance our ability to be free and to be responsible.
Very well summarized, but let's illustrate it because examples are always helpful, David, in these things. We say each of us is responsible for the conduct, to direct the conduct of his or her own life. That's what self-government is about. But of course, that creates a problem in that we each have to deal with every other.
Yes.
And we are therefore exposed. We have certain vulnerabilities, among which is the vulnerability to fraud and deceit.
And false witness.
False witness. So one of the things we want a government to protect us from is fraud. Not to protect us in terms of making decisions for us, but protect us in providing legal remedies to cure fraud, which undermines our conduct, our own self-guidance. So we can see government stands in a protective role in that way, enabling us to continue to guide our own conduct in life and to do so without undue fear of being exploited or otherwise abused by others.
Here's a trivial illustration. Would it be fair to say that the government is the referee?
It is more than the referee in the sense that it issues proscriptions, says you may not do certain things, and then it has the responsibility to enforce those prescriptions. But those all amount to a scaffolding of protection for us as we build our lives. And we all know that the scaffold within which a building rises is not part of the building.
That's critical. A scaffold by which the building rises is not part of the building.
Correct.
So we started with ourselves, we moved to the states, and then our third action was, and third in order of sequence by design, and I would submit third in declension as of importance. It's first my responsibility, then my state, then the federal system that came together to be established by a Congress established representing the 13 independent states that had won the war for independence, who now came together representing those members, representing the people, to say, this is how we'll create a federal system. Do I have it in the right order?
Yes, except there's this one thing that's really important to understand, and this was discussed at length in the Constitutional Convention of 1787. Whether the federal government represents the states or the people is the critical question. And it was enforced at the Constitutional Convention that there will be legitimacy only if it represents the people as a whole and not represents only the states. That's why the states did not ratify the Constitution. People often fail to understand that. They have set up a deliberate procedure of ratification through conventions in the states because it was the people ratifying, not the state governments ratifying. So that the federal government is directly accountable to the people as a whole and not just to the governments of the states.
Thus, the words "we the people" really did mean "we the people."
Exactly so. Exactly so.
Does that mean that we the people are responsible to this day for this Constitution?
It does, and ever will be. And it's not just that we're responsible for it, but to return to our opening discussion, where we have this seasickness-inducing movement from one era to the next and what looks like instability. The Constitution must be open to those kinds of changes in public will, the expression of public will, that could endanger the Constitution itself. It's what I have in other writings called good-willed abandonment. The people have a right to choose not to live as they had agreed to live at any given point in time. That is their right, because the rights are fundamentally individual, and they become collective not through governmental structure, but only through the concurrent expression of individual consent. It takes all the individuals consenting to authorize and legitimize the government. And when I say all, of course, I'm not speaking in some utopian fashion. It doesn't necessarily require unanimity, but it requires something so close to unanimity that it gains the force of unanimity.
Mm-hmm. Mm-hmm. So I look at the current Constitution of the United States. I see that the 16th Amendment, the Congress shall have power to lay and collect taxes on incomes, etc. Let's just say that the people decided we're really sick of paying income taxes to the federal government. Could the people pass an amendment? Or how would the people, I know this is basic citizenship 101, but since most of us have forgotten, how would people go ahead and change that?
A constitutional amendment. And that means to say that they would, of course, in our present system, petition their representatives, whether in the states or in the federal government, because there are two separate routes. One proceeds through the states, the other proceeds from the federal government down to the states. Either route is approved in the constitutional provision for amending the Constitution. So that can, in fact, be done, just as we saw occur with respect to prohibition. It was adopted following procedures. It was unadopted following procedures. People can at any time alter the Constitution. So when Breyer emphasizes the need to adapt the Constitution to changing circumstances on the theory that the framers could not foresee every possible circumstance that would arise in the future, he is misstating the situation. They foresaw that there would be changes, and they recognized the people's right to change as they experienced changes. They did not assign that to judges to do for them, or legislators, or presidents. They assigned it to the people.
There's more important conversation to come on this important issue with Dave Zanotti and Dr. William B. Allen as you stay tuned for the rest of today's edition of The Public Square. Online, thepublicsquare.com.
We will be right back for more on The Public Square.
Introducing the latest program from The Public Square.
Kids on the Square.
We at Kids on the Square are dedicated to helping teach the next generation through topics like Bible stories, scientific marvels, and American history. We want to equip parents with fun and free educational resources to share the truth with their children. Won't you join us? New episodes are released monthly. You can listen wherever podcasts are available and visit kidsonthesquare.com to find out more. Thank you, and
welcome to Kids on the Square.
Spreading the light of liberty across the land. Now back to the Public Square.
We're listening to a conversation Dave Zanotti had recently with Dr. William B. Allen after reading an article written by Supreme Court retired Justice Stephen Breyer. Let's return to Dave and Dr. Allen now as they continue to react to the article.
The doorway to change, to make the Constitution as contemporary as the people choose, has no lock on it.
Exactly.
The people can walk through it any time, follow the proper channels, and modify their Constitution.
Precisely so. Which means, of course, it is not necessary for members of the Supreme Court or of the Congress or the executive branch to take on the superintending role of making those changes in the name of the people.
Yet when I read Justice Breyer and I look at his colleagues, his former colleagues on the court, at least three of them, they seem to feel that it is their responsibility not just to tell us what the Constitution means, but what it should mean.
It goes beyond even that. Justice Breyer is quite explicit, as you see in the discussion in Active Liberty, that it is a judge's duty to arrive at a decision that helps the people. Now, that is not a legal standard. Legal standards focus on what the Constitution calls cases and controversies. They decide individual cases. They do not decide the fate of the society. Only when judges confine themselves to deciding individual cases on the basis of the law are they being judges. When they issue opinions that are meant to have general impact on the society at large, they cease to be judges.
What are they?
They become at that point legislators, though they're not assigned that responsibility.
What examples come to mind to you where you've seen that happen?
Well, of course, we've seen so many of them, and the most notorious, of course, was always the Dred Scott decision, in which the court made the judgment that it was going to settle the question of slavery for society as a whole, rather than simply deciding the single case that was before them of whether Dred Scott, who'd been carried into a free state, had gained his freedom, which it could have confined its decision to that, but it sought to instead extend it in order to govern the developing narrative, the developing discourse throughout the entire country. So that's the most egregious example. And we've seen numerous examples since then. We saw that in Lochner versus New York when they were dealing with wages and hours and whether the government had the authority to regulate those. And as we said a few moments ago, government protects the individual in the exercise of the individual's right to conduct his or her own life. When government goes beyond that and starts guiding that and making decisions for the individual, it exceeds its legitimate authority. Where wages and hours are concerned, government does that, courts do that because they think it's healthier for people. And they have, in other words, preempted the people's right to decide for themselves what is healthy for them or what is advantageous for them in contractual terms, and a number of other such things. And it is that difference that explains the difference between Breyer's approach and the approaches that Breyer criticizes.
Let's talk about those approaches that he criticizes, the textualists or the original intent folks. And of course, you can't go very far without Antonin Scalia's name coming up. And there seems to be still a deep controversy between wings of the court about how do you read a statute? How do you read an amendment? How do you know what you know? With the epistemology of the role of the Supreme Court, they're very, very deeply confused.
They are, and they're confused among those who regard themselves as originalists or original intent jurisprudence. And it's of course Scalia. Before Scalia, it was Robert Bork who became the poster child for this particular development. But since that time, there have been emerging trends and quite a bit of dissent among the originalists themselves. That's exactly what this means. Whether you're supposed to ferret out the intention of the framers or the intentions of the people who ratified, whether you're supposed to ferret out the language as it was understood in common parlance at the time that the language was written, or whether the language as it was understood among legal experts at the time that the language was written, and on and on. So they have differences among themselves. But There's a fundamental foundation of textualism or original intent jurisprudence, which is undeniable, and that is you're not interpreting the Constitution unless you're interpreting the Constitution that was adopted. It is not some vision of what a Constitution might be that should govern a judge's decision. It should only be an understanding of what the Constitution was when it was adopted. Then you run into the epistemological question of how do we determine just what it was when it was adopted? And that requires very patient reconstruction. People use things like legislative histories, whether for statutes or constitutions, because they end up looking for purposes. And one of the things that is often neglected, and you see this show up a lot in Breyer's writing, he talks purposes all throughout, but he never clarifies when he talks about purposes, whether he means purpose stated in the statute or the Constitution, or merely purpose that is stated in discussions but not included in the text, or maybe purposes that were never even stated and that were unstated purposes. He doesn't clarify that distinction of purposes, which means he ends up reducing constitutional interpretation to the search for the one thing that no intelligence can ever identify, which is the motives of those who have acted or written or spoken. None of us has access to anyone else's motives. So even if one states a purpose, it is not certain that the purpose is feigned or unfeigned. We don't know what the unstated purpose might be, even when someone declares a purpose. So this looking for purpose apart from what is stated in the text proves to be a fool's errand. One has to face the reality that constitutional interpretation requires us to accept the clear and coherent statement of the law, even in the face of intractable difficulties or consequences that result from it, leaving to the broader political system to resolve those intractable difficulties rather than trying to resolve them judicially.
So many questions. I'm going to, before I jump to another modern example, I want to go back to the text of the document that I'm holding in my hands.
Mm-hmm.
You know, this was written in 1787 and it was ratified in 1789, and I read it regularly, and it still looks like English to me.
Yes.
It still reads, there are not a lot of 7-syllable words in this document. There are a couple of words that to be clear, I want to make sure I go back to like a Webster's Dictionary of 1828 to make sure I haven't put a modern internet meaning onto a word that came up before the internet.
Right.
But when I could just pick any single page and start to read and say, it seems to me that the writers of this were trying very hard to be quite clear with their intentions.
You know how you can decide that question very easily? Compare it to the published disputations about the Constitution. People often make the observation that Federalist Papers are so hard to read. Now, I have, of course, refuted that, said it's not hard to read at all. Anyone who is literate can read it and understand it. Nevertheless, it is perfectly clear that compared to the Federalist Papers, the Constitution is as simple and clear as a document can be. And therefore, it makes no sense to declare that there's anything ancient or unapproachable in it.
I tell you that I have plenty of instructions for sound equipment that come into our studio every day that I have to read that are much more complicated than this.
Yes.
I mean, the directions. There are some cereal boxes that read more complicated than this. This is not designed to mystify the reader.
It's not written for experts. Surprise. It's written for the people. So it lacks the obfuscation that expert writings often project.
But you do have to admit Hamilton does get a little thorny in the Federalist Papers, right?
Well, I suggest he's as clear as a bell, but that's okay.
And you have a full commentary on the Federalist Papers, among all of the writings that you've done.
Quite so. But one thing is clear, though, that nothing in the Federalist Papers is quite so clear as the Constitution itself is.
The conversation will continue with Dave Zanotti and Dr. Allen coming up in a moment here on The Public Square. Make sure you download our free smartphone app, The Public Square, free in your app store.
Recently, we introduced the work of Mission Eurasia here on the Public Square. This missionary outreach has been training up new biblical leadership across the former Soviet Union for such a time as this. In the midst of the crisis in Ukraine, Mission Eurasia set out to help the wounded, displaced, and the refugees. Because of the prayer-filled support of Christian people around the world, Mission Eurasia has gathered up over $2 million to assist Ukrainians in desperate need. Those funds are going straight to the field to help hurting people. Many of those dollars have come from the listeners to the Public Square. Thank you for your faithfulness. To learn more, please visit missioneurasia.org.
A few more minutes now of conversation with Dave Zanotti and Dr. William B. Allen, reacting to the writing of Stephen F. Breyer, retired Supreme Court Justice.
Okay, so let's jump into some examples of this. One that jumps very quickly into mind was the conflict over Obamacare and the question of, was this a tax or was it a fee or was it a penalty? And the entire question before the court seemed to hinge on whether or not Congress acted the right way or the wrong way. And it came down to a very narrow decision, and the Chief Justice basically called it what he wanted it to be. And it sure seemed like at that stage in the game, he took the robe off and basically became a super Congress of himself.
It's clear that he was acting in the manner that Breyer prescribes for judges in that case. And he asked himself, what can we do to save this law? Because he conceived that it was helpful to the people. And the one thing he could do to save it within the square meaning of the Constitution was to call it a tax, which is clearly authorized in the Constitution.
But had it been a penalty,
had it been something else, he would have had to decide differently.
Because it would have been the government forcing people to basically buy a product that they didn't want.
Yes.
And so John Roberts, of his own volition, and I'm sure he was as sincerely motivated as he believed he could be, I know when I heard the decision, I literally went to my knees and prayed for God's mercy because I realized what a tragic consequence this would be with him making that decision.
Well, he made that decision, as I said, for what we might call reasons of judicial prudence rather than reasons of judicial reasoning.
And let's just take a second and say, okay, wait a minute. You know, there's multiple passages in the Bible that warn us all to not think more highly of ourselves than we ought.
Yes,
I would quote
right so.
Romans chapter 12 as a specific one. If John Roberts had decided to go a different direction and said, you know what, this law is a mistake. It's clear. It's clear to everyone. The statute is clear. This is a penalty. Reject the law and based on constitutional understandings, make a right ruling and let Congress fix it. What are the odds that within 6 months Congress would have had a better law crafted?
That's the answer to the $64,000 question. Why not simply tell the truth and let Congress face up to the reality it needs to do it again? Why not? That's because judges don't have confidence in democracy.
Let's go now to, in our lifetimes, what I think arguably, or maybe perhaps no longer without contest, the greatest moment of judicial activism, which was Roe versus Wade. Not only was it the greatest moment for 50 years that all of us spoke about, but finally the court did something that it's not prone to do very often, which was not just to change its mind, but to repent and state that it had been wrong all along.
Right. When I mentioned Dred Scott as the egregious example, it was with Roe in the back of my mind, because Roe followed in the path of Dred Scott. It looked upon what it regarded to be a social dilemma and decided its job was to solve the social dilemma rather than to read the law. And that produced what? 2 generations of strife and continuing, because court got out ahead of its responsibility and ahead of the public. The public reacted, not with a constitutional amendment, but with a continuing discourse about what was right and what was wrong. So that ultimately it led to Dobbs and the reversal of that decision. But it's very important to understand that the reversal in Dobbs was not the court saying one day, we made a mistake and we're going to change it. It was as much a reflection of the pattern of development since 1973 throughout the entire society as anything else. And that's what the court buys when it starts making its decisions on the basis of social utility rather than legal necessity.
It was embarrassing for 50 years to watch the court perpetually attempt to find a way to get another stitch to hold, or any stitch to hold, between abortion and this simple document that I hold in my hands, since the word abortion or nothing even like it appears in the document.
Nothing like it appears.
That the framers would never have wanted the federal government to be the original source of resolving this kind of a question. This was clearly up to the people and the states. There were abortions that happened in 1787. This isn't a new invention of the modern era. They chose systematically a whole lot of things that the court plays around in today to not be involved in because it's not there. That's not the purpose of this document. And yet the court, in its utilitarian, or as Breyer might say, its pragmatic approach, which I guess is saying, if you all can't get it together to the level of my satisfaction, I'll fix it for you.
That's exactly what's being said. And more than that, it's saying I have a responsibility to fix it. It's this assumption of responsibility. That's the unconstitutional aspect of Breyer's attitude.
Boy, I'll tell you, when they start talking about stare decisis, I feel like they're walking in tar. They're just, their feet are getting stuck and their shoes are being sucked off their feet. In other words, precedent. The whole thing is precedent. If it's been precedent for 100 years, we can't change it. Well, what if you were wrong for 100 years? I mean, here these guys are saying we need to change the Constitution to make it contemporary because we're learning things every day, but we can't learn we were wrong.
Well, another way to frame this is to say, remember, Roe was an innovation. There had not been a previous case at that level affirming that abortion was illegal or unconstitutional, and therefore Roe was not overturning anything. In that sense, it was an innovation. Now, it takes an extraordinary degree of hubris to say any innovation becomes, by merely being adopted once, a continuing obligation, which is what stare decisis comes to mean. And you can appreciate the irony of all this when you understand that you're applying this stare decisis legal rule to the development of judicial opinions and not applying it to the Constitution. That's a text. That was once an innovation. Why isn't it stare decisis? It is not, in Justice Breyer's view.
Our thanks to Dr. William B. Allen and to Dave Zanotti for the conversation today. Now, Dave stays with us, and our panel joins us coming up in a moment on the Public Square. If you have to leave us at this time, hear the rest of this program online at thepublicsquare.com. All right, we heard an incredible conversation just now with Dr. William B. Allen and our own Dave Zanotti here. So let's talk about it as a panel. I'm Wayne Shepherd here with Alan C. Duncan, our producer, and Dave is back with us, of course, and Rob Walgate and Jeff Sanders and Melanie Elsey. So who wants to stick their hand in the air and react to what we've heard here?
Well, I know we talked about the article with former Justice Breyer, and I was in the car listening to an interview not long ago with a congressional candidate. It was a candidate that currently serves in the General Assembly of a state legislature. And he was talking about elections and why elections matter. And this boils it down to the state level. And he said that the most important election each year when someone votes is who they vote for Supreme Court in the state. It's more important than in the legislative body. And I almost wrecked my car. And this was a Republican candidate. And I'm like, you have got to be kidding me. Does he not understand the Constitution and the construct of law and what his role as a state legislator is in this dynamic? I just couldn't believe it. So I want to forward on to him what Dr. Allen had to say. I think that would be a great, I think every member of every General Assembly across the country and member of Congress should listen to what Dr. Allen had to say.
Every citizen needs to do that, Rob. It's not just the people we elect. We, the people, need to understand the Constitution.
I learned a new term today, judicial legislator. That describes it, doesn't it?
Yeah, it's kind of what's called a non sequitur.
Yes, right.
It's and Rob, I think what we're talking about now is the virus that has infected our culture. Our understanding of governance is that we literally believe, as you have said best, and I've heard you say it a lot of times, we wait as a people for the Supreme Court to tell us, through its rulings, what the law is. That's not what this country is supposed to be. Whereas the lawmaking authority does not come from the court. It comes from the legislative branch, whether we're dealing with the state or the federal level. But we're caught in this terrible mythology. And part of what we need to do here on the public square, and that means we need every listener's help, is we've got to break the spell here and remind people how this is supposed to work.
I just felt like when I was listening to Dr. Allen, I was in the classroom listening to a very wise man who has read just about everything that there is to read. And he was gently lecturing and explaining to me, someone who is not all that wise or intelligent when it comes to matters of the law. And I greatly appreciate it. But one thing a term that he came up with, or that Justice Breyer had, was active liberty. I'd never heard of that before.
Yeah.
And so what does that mean? And he was explaining that it's what we've been seeing an out-of-control court do for the past 50 to 60 years.
Well, and I was thinking about that this morning, Jeff, and Joe Biden, the president of the United States, does the same sort of rhetoric. He basically will say, this is America. We're Americans. If we all get together, look at how much good we can do and how many people we can help. And that sounds like, yeah, rah, rah, go, Mr. President. The Supreme Court's not supposed to be in existence to do good for people. Now, it's not supposed to do evil either. The Supreme Court has a specific role. It's an appellate court that's supposed to hear disputes. It's not supposed to be some social service agency. Neither is the collective reality of our civil government. And what ends up happening is we've misunderstood the right role of government.
Well, and I think we misunderstand that sometimes staying in your lane is in itself a good.
Right.
You think, I want to do good. Well, then do your job.
Mm-hmm.
Yeah. Okay. The court was never envisioned to be a political arm of a political party. It's because when the court came about, there weren't political parties. So no one would envision it being an arm of a political party. But also, to go back, to think of the most recent State of the Union address. And the court got a lecture, unlike any they'd received before, from the commander-in-chief, from the president of the United States. And I think that took a lot of people kind of like looking around saying, what's going on here?
Well, it's not the first time.
Right.
I remember Barack Obama doing the same thing.
Yeah. Yeah, that was vengeful, and that's a risky place to be. Well, there's so much more to talk about this, but I think If we could wrap up this classroom session, what we would want to say is it would be great if this mythology could drop away from us, if we could just get the right prescription, take a few pills, and in a week we'll be better. But I think we're going to be at this fight for a lot of years to come, and that means elections really, truly matter. When I look at the existing court, people think it's a 6-3 conservative court. It's not, friends. There are 4 people on that court that get what Dr. Allen was talking about, just 4. They're not the majority. They're just 4. There are 3 who are diametrically opposed to what Dr. Allen just talked about. The court's 4-3. And there are 2 who aren't exactly sure where they come down on all of this.
Mm-hmm.
So it's a court that's 4, 3, and 2. What that means is to protect this republic, we have to be very careful about who we elect to the United States Senate, that body that confirms justices, and who we elect to the presidency, that branch that appoints justices. And if we don't, this court could flip in a heartbeat, and we could be in a lot of trouble. It's trending toward the right direction, but don't kid yourself. It is not a conservative court.
I wish we had some high school students in here recently, and I wish that every high school in America could listen to this broadcast with Dr. Allen or listen to something else where he teaches this topic. This is not something I remember learning in high school. I don't know about the rest of you, but it's very basic. But it's profound. And it makes a lot of sense. I think if people could learn these concepts, it would really help us understand the government and just our country.
And I think the bigger challenge is, even if you understand these concepts, how do you parse that with the process of making sure that the person who is nominated and confirmed, when we don't have a record of their motivations, their thought process, we have a record of their decisions sometimes. But I mean, the reason why I'm saying that, I'm listening to hearings in the confirmation process, and I'm listening to potential candidates for the federal appellate level, where the candidate doesn't even, if asked, describe Article 3 for me, describe Article 2 for me. They can't do it. And those are people that are being nominated to go through a very arduous process.
We have to control the nominators.
Yeah. You know, in the vein of what, Alan, you said, and Melanie, what you said, and earlier what you said, Jeff, about listening and feeling you're in the classroom, I honestly listened to that and I felt, if Dr. Allen had been alive at the time of the framing of he should have been part of the framing of the Constitution, the way he describes it. And it's underlined. Wouldn't that be something?
So true.
Well stated, Wayne. You know, Dr. Allen is one of the 7 anchor authors of the library here at the American Mission Center.
Mm-hmm.
And his is the biggest section, to be sure. One of those sections covers his work on writing a commentary on the Federalist Papers.
Oh, boy.
Now, how would you like that task? That's just one of the books that we have his research for in this library and copies of that book. My goal and my hope is that as years go by, that the kind of instruction we're talking about right now flows from this American Mission Center in every technological way possible, and that this library has visitors every day, and that the education center that we hope to build next will host events every day. There'll be live broadcasts for homeschoolers and for AP high school history classes, and that we can get this information out. It's got to be done. And our prayer is that the Lord will bring people along to help us make that vision a reality.
Last word, Jeff.
I've got a suggestion. If you want to understand the Constitution, go back and read what our founding fathers read. This is what saturated their minds. Go back and read Montesquieu. Go back and read Plutarch's Lives. Go back and read Aristotle's Ethics. Go read these documents. Then you will be able to go to the Constitution, and it's not that difficult. Then you'll be able to go to the Constitution with their framework and say, oh, that's what they meant in the Second Amendment, the First Amendment, the 10th Amendment, and so forth.
Did we mention Dr. Allen did a commentary on Montesquieu also?
Right.
Yeah, I think we did a whole program on that. Yeah. And that's in the archive, by the way. Hey, thanks all. Dave, thanks for bringing that to us here today in the Public Square. And thank you for listening. Thanks for your support of the American Policy Roundtable.
Public Square is a broadcast service of the American Policy Roundtable.